everybody. Welcome to HR Nightmares. You are here with Lisa Leith and
Amy Conway
and
Beth Looney.
And we've got an awesome guest here today. She's a great partner for us at Leith HR Group. It's Katie Greene. She's an employment attorney that we've known for actually quite a while now. Mm-hmm. But she works for Michael Best. And they do all kinds of different, I'll let you explain Michael Best in the firm, but they do all kinds of different business legal advice. But we love working with Katie and her team on all things HR related and employment law related. And so we're going to take advantage of having her in the studio today. And we've got a couple of audience write-ins that I'll turn over to Amy at the end of the episode so that we can all dive in and give some advice. Just a reminder, we're HR consultants, but we're not your HR consultants. And Katie Greene is our attorney, but she's not your attorney yet, but feel free to call her. We'll give your contact information at the end of the episode, but let's dive in. I mean, it's been fun working with you as of late with a couple of clients, and we won't talk about those specific instances because they're nice and hot. But we've got a bunch of different topics that we want to talk to you about, including things that are hot on your radar right now that you pitched. Non-competes. People are like, can we do them? Can we not do them? Am I allowed? We've also got things like the overtime and fair labor standards, exemption ruling. Is it real? Is it not? We've gone through this several times in the last 15 years and it never kind of panned out. And then anything else, if we got stories, this is HR Nightmares, so we love a good story, a nice salacious story to throw at our audience. But any other things now that it's always fun to have an employment attorney in the studio. Any other hot topics y'all want to make sure that we hit Katie Greene with?
Yeah, I mean, I always like to know just what's trending. I think I'm sometimes a fear monger with my clients because I come from such a large company and a corporate background, and I had so many issues all the time, and they're kind of tiny and they haven't really dealt with a lot of those serious issues, but I'm constantly the one that's but it could happen, right? So I'm just curious, especially in this area in North Carolina, what you're seeing is some of the big trends, because I think that they change from year to year a little bit based on kind of what's going on in just our world.
Yeah, absolutely. Well, first, I'm so happy to be here. It's kind of a cool full circle moment, right?
Yeah.
I've been a client of you guys, and now we get to partner together, and I get to be here. So that's just awesome. But hot topics this summer, I mean, we have so many to pick from, right? I was kind of going through some notes to get ready, and we had the non-compete ban and the overtime rule drop on the same day in April.
Mm-hmm. Is it true?
Yeah, April 23rd.
Same day.
I kind of blacked it all out. It's been so many different things this summer, but it's been a busy summer in employment law land. So a lot going on. We're watching a lot of court cases closely and trying to get clients ready for no matter what happens, right? We should be looking at these issues for you either way we shake out on the rule going into effect or not. So a lot of cool things to talk about. Should we start with the non-competes?
Yeah, let's.
Yeah, I want to start there, but tell us how you got here. Why are you in love with employment law? You weren't planning maybe on doing total employment law, right? You started somewhere else, and so how'd you land here?
Yeah, absolutely. So my background, I'm newer to the practice of employment law, but my background has always been heavily in disputes generally. So heavy litigation background, commercial disputes, anything in a general civil practice I've kind of done at some point. But when I was thinking about where do I really want to focus my career, I love the aspect of employment law where you get to be that strategic partner with the client, right? I work with people who are hiring their first employee. And they're literally what do I do, right? What do I need to have in place? What forms do I need to have to fill out? Or really large, sophisticated employers who need to do a reduction in force and a right sizing. So you see so many different things. You're there for cool moments, for growth. And at the end of the day, people are fascinating, right? And HR and employment is all about people and what they're up to and maybe some things they shouldn't have been up to. So you're challenged, you're interested. It's never a dull day. It's a lot of busy days, but it's never a dull day.
That's true. People are
crazy.
crazy.
It's certainly entertaining throughout the years. When I think back, I'm it's an entertainment I didn't necessarily want or ask for, but it did kept my weeks busy and moving along.
Yeah, it keeps it real.
Yeah.
All right, let's talk about non-competes.
Do we still have them? Great question. We don't know. So in April, we got the announcement that the FTC had issued its rule saying we don't have non-competes anymore. It was super broad. It's not just for employees. It applies to independent contractors. It applies to interns, volunteers, basically anybody who's performing a service in any capacity. Their rule would put into place that you can't have a non-compete. There's a really small exception for people deemed senior executives, so you have to make a certain amount of money. It's a little over $150,000 and have a certain policy level decision-making abilities. If they were already in one, it could remain. The rule goes into effect September 4th. So if you have non-competes in place that would no longer be valid, you've got to notify those folks by September 4th, and you can't enter into any new ones after that. So right away, we had lawsuits filed, right, challenging this. This is a huge deal. And so we have two that we're watching closely that are kind of working their way up in Texas and in Pennsylvania. Right before July 4th, the Texas court issued an injunction, so staying the rule from going into effect, but it was only for the specific plaintiffs who brought that case. It was not a nationwide stay of the rule going into effect. And in making that decision, the judge basically said that the FTC didn't have the authority to issue this rule. They've issued kind of an interesting timeline in that they've told us when they're going to make a final ruling. Usually you don't get that, a court issues an order when they issue it, but they're going to rule by August 30th. Because of what was said in that original opinion, a lot of people think it's likely going to strike down the FTC rule. But last week, we got a decision in a Pennsylvania case that's completely opposite.
Oh. Yeah, I saw that. That was the one I was reading about. Yeah.
So basically, everything the Texas decision held, the Pennsylvania court held the exact opposite, that the FTC did have authority to issue the rule, that the folks who brought the case weren't showing they had sufficient harm, and that they weren't likely to succeed on the merits of the case. So we've got these two completely opposite decisions. So everybody's waiting for August 30th to see what that follow-up ruling is going to be. We're likely going to have two opposite decisions working their way up through the court system. So we're keeping an eye on it. But even if the FTC decision doesn't go into effect in full or in part, I think it's just a really important moment for employers who are thinking about using non-competes generally, right? I was looking at a survey, and I think we're up to 38 states. I was doing math on the fly, so, we'll say 38-ish, that have some type of restriction on non-competes to begin with. And, right, that's not even putting the FTC restrictions into place. So they're so scrutinized already at a lot of levels. If you have employees in multiple states, you're probably going to be touching a state that has put some type of limitations on them. So it's a really interesting moment for them. I think the tide is really sort of shifting, and it's important for employers to keep an eye out and also to know, do I have other protections in place in case the non-compete isn't good anymore, or if I can't use it in these states where I have employees.
Yeah, I think it's interesting. So I sat on a SHRM webinar because I got to get those recertification credits, and so I sat on a webinar because I was interested in the topic, and they were having a webinar on that. And in SHRM, I guess I'm pretty opinionated on this one, but SHRM was didn't feel like their statement that they made before the legal person got on and actually did the presentation, they made a statement, and it didn't seem like they were in total support of the ban. It kind of said we believe there was probably a middle ground. So they did say that, but it's interesting because I actually am not a fan of non-competes. I just don't know. I think maybe sometimes they serve a purpose, but at the same time, I think that we have to be really cautious to prohibit people to go out and use their skills to earn a living. And I think non-competes, quite frankly, sometimes are used by companies to gain lifelong loyalty. And that's really not the point. And there's other ways and other systems to make sure you're protecting your business, other than making sure that that person is guaranteeing that they're not going to leave and go out and be able to use their skills, which are typically specialized, and they're going to go use that same skill set somewhere else. So I'm not a fan.
Well, you got to think about this though. So I think technically, I think about the software engineers at Vanica, and we have one main competitor in the industry, and the full intention of our restricted covenant is to not go work for basically that one main competitor. And so it's not that you can't go use your SQL skills and C# skills and all those software engineering skills with the competitor. I just don't want you taking our trade secrets and going and sharing our business model with them. Similarly, it's kind of like with you guys as consultants for Leith HR Group. It's like, there's only really one kind of HR consulting firm in this town. It's like, I don't want you taking our business model and like going and running to somebody like a competitor here. It just feels weird.
Well, I think that's probably like what I don't agree with necessarily, right? Because like that's my skill. So like what am I going to do? You know, so it really limits, you know, that person and that employee's option. And I don't know. I think sometimes it's like we're making the assumption that they're going to go like steal those trade secrets versus just going and using their skills, which, you know, there's other employers of choice out there. So,
well, that's a question I've got. So I know that some of the clients that I have, they wrap three things into one. So they do the non-compete, non-disclosure, and the confidentiality into one document. So with this new law, will the confidentiality and the non-disclosure still be enforceable? Or is this getting rid of every single piece of that?
So the FTC's rule is only addressed at non-competes, and there's a lot of language throughout. First of all, it's very long. I think that's part of the criticism, too, is that there's even things that are not defined or that are difficult to understand. So even if it goes into effect, we're all going to have a lot of litigation over some of these terms to even fully understand what they mean and how it works in practice. But the goal is only to affect non-competes. Non-disclosures, confidentiality are specifically addressed, and the intent is not to invalidate those or not to do away with those. The one that's more up in the air is non-solicitation clauses. So you can't ask your coworkers to leave with you and start a new company. You can't go after your customers you worked with at company A when you go to company B and say, hey, come with me, I'll cut you a better rate, right? Those are not covered by the rule. So the thought now is they would be exempted, but if your non-solicit is so broad that it effectively acts as a non-compete, it could be brought under the coverage as well. So I think the key takeaway for employers is be strategic and think about what you actually want to protect. Like Lisa, what you're describing is exactly right. We want to make sure those trade secrets are protected. Maybe we have some really key competitors, whether it's in the industry or in a local area. Write it narrowly to protect the things that are actually important to you. We find people who, you know, take a form off the internet and it's super broad. You can't practice veterinary medicine anywhere in the US for 10 years, right?
That's
like
crazy.
That's probably not going to be enforced anywhere, but really think about what's important to protect your business and draw your documents with that in mind.
Yeah, and I think that especially with some of the companies that I have in my little book of business, they have very specific knowledge bases. It's very like proprietary. They've spent years and years in R&D, and I think to lose that, they get nervous about it. So they still really want to keep all of those trade secrets.
Without a non-compete, and like the argument could be like, well, I'm going to go work for a competitor, but I'm not going to share any of the things. Well, that's just ludicrous. Like you're 100% going to use what you learned at my company to go at a competitor. Like, and how would I ever go prove that you didn't? You know what I mean? Like trade secrets. Like it's really hard to go. I don't know. It's just without the non-compete, you can't prove that they were using your trade secrets, but you know that they will because it's human nature and it's their experience and skills they've earned from being at
I think that's why like a lot of the non-competes and why the FTC has limited maybe the kinds of rules and people who should have those too. So I think that some of it is like we've seen companies go out and give a non-compete to just about every person. It's like these are people in non-decision making. They're not impacting. They're just doing the data. They're doing the work. Sure, they have a seat at the table sometimes, but they're not responsible for the strategy of that company. And we see companies giving them non-compete. So I think that's the whole thing of like, okay, we're maybe overusing this and we're tying the hands of people to be able to go out and have different experiences or to create their own business and we're operating that like scarcity mindset where we're scared to lose those people that have the institutional knowledge, but that's just part of it. We got those people from somewhere else. So that's part of employment, and having people is they're going to move in and out of your company. And I think that like the more I read about it, it's like, this is kind of the intent, unless we have some guidelines out there to help also protect the employees against kind of those blanketed type clauses.
Yeah, absolutely. And I think another piece that's often left out of this, which is also usually part of a conversation I have with a client when we're talking about how do we protect these things, what are our real concerns, defining and knowing those trade secrets, right? Like, it's not enough to simply have someone sign your confidentiality agreement that I understand I can't take information and I can't use it if I go to someone else. What are we actually doing to protect that, right? Are we having employees who have to log in on a secure system to work? Are we making sure we know if they have downloaded or accessed something they haven't? If they leave, are we making sure we've gotten all of our data back, right? So there are things from it's really a technology, right? And sort of a protection of your information outside those employee agreements. Of course, we want to thank everyone who signs our documents when they work with us, and when they leave, are going to uphold them. But we've also got to take steps as employers to protect that information as well, not just relying on those promises and agreements.
Yeah, I think it's funny. So I do executive coaching too, and I do work on one of these new like tech platforms that kind of offer coaching services and have all these coaches, and I'm an independent contractor for them, and I've been doing that for years. And I remember when I first started, I almost laughed. I mean, I so quickly signed the NDA and the confidentiality or compete. I don't even know what all was in it. There was a lot of information in it. And I was thinking to myself, like, I could care less about your technology and like what you're doing. That's what it was. It was to protect the technology. These are new platforms, right? And there's a lot of competitors in this space. But I'm thinking like, I'm just a coach. I'm just trying to like help more clients and have more revenue. And I'm like, I can barely log into this system, let alone am I going out and giving any of this platform to any. So that's what I mean of like, was that necessary? All these coaches, we're just trying to help clients with their career goals and leadership. And we all got these massive like 20-page documents that we signed away. I'm like, I barely have time to work for your organization, so no, I'm not going to go out there and also work for another one.
The info security is a real issue, interesting. Though. I mean, like, so we've even got, things in place at our company, our software company, to flag when somebody logs in from a different IP address, because they're basically trying to get competitive intelligence for our one main competitor. We're pretty sure about it. So I sort of like understand why they're doing that, because you could give the login to one of their competitors that's a friend of yours or that you run with, and like, so you don't want people sort of snooping around and peeking around to try to steal what you've got going on from a software stand. Software is weird.
But like weird. In my situation, I'm like, there's at least 10 or 20 of these companies that have all popped up in the last 5 years. So like, it's not, you have to be able to live with some competition and know that there's plenty of business out there too. I guess that's why I just sometimes don't understand all of the non-competes. I don't think anyone at my organization had a non-compete, and think of how competitive of an industry that was. Companies going out of business every other day in that industry because of competition. But it's just...
Well, I know working sometimes as a fundraiser in nonprofit organizations, their non-compete I thought was fair, because the relationships that you built while you were on their dime.
The donor stuff.
Yeah, and you knew all the donors, and you knew what they were likely to give to. You knew kind of what they were able to contribute. And then if you go to another competitor, because there are very few competitors, there's only a handful of nonprofits that are really attracting the higher donors. And so they really outlined exactly who you couldn't go after. And it was actually written in, like, you can't go after, list out the names of the people. And I thought that was fair. And I think when you sign something like that, you're exactly right. You need to understand what you're signing. And I often see there's so many younger people that are just, their new hire paperwork. It's like, sign this, sign this, sign this. And it's like, where's the signature page? It's 14 pages in. And I don't think they ever take the time to read that. And they probably don't know what they're signing.
On the flip side, how often are you seeing employers go after employees that have violated their non-compete?
That's a great question. And again, that's a conversation I have with people a lot, is like, do you have the resources and the capacity and the appetite to enforce this aggressively?
Yeah.
Right. So some of it is just, we have this and it's a deterrent, full stop.
Right.
You know, we've told you you can't
That's
do
what it
it. You
usually is.
signed it. The expense on both sides of going after something like that, and especially in that type of situation where you're asking the court for that early relief, right? You know, they've left my company, they're going to work for company B, we're trying to get the court to order that to stop immediately. That's almost a mini trial, right? Before you've even started any real litigation. So it really varies based on the employer's size, appetite, financial capacity, but for certain industries, certain key positions, it's there. They will go after it.
When I worked in pharma, we would like send a letter, then we'd send another letter from the attorney, and then we'd sue them. Mm-hmm. But we had a lot of money.
Yeah, it depends on the
I just told a
industry.
client last week, I was like, are you really going to go? I mean, I said, are you really going to pursue that? I mean, it was like on the table. I'm like, okay, but you're opening a can of worms of what that person could come back with. And like, we don't know, like they left, there was a little unknown. Like, it sounds like there were bigger things brewing underneath that we were not made aware of. Do you want to open that can of worms? Because we could be bringing more risk on ourselves, or we can just let it go. And that was pretty much what was decided, because it was a very unknown. I'm like, it's risky and I don't think it's worth it.
And it's never covered by EPLI, like going after, like litigating.
An affirmative?
Yeah.
No.
Yeah, that's just defensive.
And you are opening yourself up for them to do a lot of discovery on your operation, and that might not be what you want.
Or they have time remaining to bring issues forward that they haven't yet. So, I mean, I think if we're thinking about enforcement, right, and if you're a company and how do I put myself in the best position if I want to have these and I want to use them, and for them to be legitimate and meaningful, a lot of times I'll see for those key executives, people who really do have sensitive knowledge, inside knowledge. A lot of times you're negotiating a severance in advance, right? Like there's some sort of exit package, or if they resign or the company terminates them under these circumstances, there's some type of negotiated payout, right? Building those payouts contingent on compliance with those things.
Right.
There are ways you can sort of creatively think about it and build in protections that's not just, okay, we're going straight to court, right? So again, you know, think about who you need it for, what you need to protect, and the policymaking executive and the front desk attendant are probably not going to get the same employment paperwork, right? They probably shouldn't be getting the same non-compete either, because they're exposed to different things.
What do you think about the whole idea now that we live in the remote world and hybrid work, where people are using their laptops and they might have access to sensitive information? And how do you really, so I guess you've got maybe guardrails on downloading that information. So what do small companies do that might not have that expertise? Like, how do they not?
Info security.
Yeah. Is that do they hire somebody? I'm not
I mean,
for
with
sure.
Microsoft and like Azure, you can see what's uploaded and downloaded. I mean, that's pretty standard.
But how would you get that back?
Get it? Oh, if it got removed, it's on the cloud.
Yeah, in terms of like if it was deleted or
Right. If somebody left and they're mad and they're not going to, then they just delete everything. How would you get that back? And I know that I probably should
Probably
know
a
the
pain in the
answer.
ass.
I mean, there's going to be some IT work there that's
Yeah,
beyond
some
my
forensic
skills.
IT stuff.
But
Yeah.
Hire an
they
IT
should
consultant.
They should be a way to
Seems
recover
so-
it.
Yeah.
I think the biggest thing for smaller employers that I run into a lot is just not having any idea what devices and what access people are using. So maybe you don't have the financial capability to have a full IT team, to have some type of secure login or whatever. You should at least know if John, Patrick, Robert, whoever at your company, if they're logging in on their personal devices, if they're using their personal laptop or their personal phones, at least know where your data is step one.
Right.
Yeah, and almost everyone uses their personal device with their Outlook and their 365 from the business or multiple clients. And so, yeah, I mean, at one point I had like 7 different emails at Leaf HR Group from like, all the different clients
Oh
on
my
my one
gosh,
personal device. But
It's
you
ridiculous.
But if you
I took
hit-
them all off. I was like, I can't. I have them
Yeah.
on my computer, but I only have my
It's
Leaf
so
HR
much.
email on my phone. I'm
Yeah,
like, it's
if
too much.
you log out from like the admin platform, though, it should log you out of the Teams, out of the office, so if you're like terminating somebody or they left and you're skeptical of their scruples, like, yeah, it should log them out of almost everything. But I think even in software, we've got like all these different platforms that people are playing in, like Sandbox and client platforms, and
Right, that they could log
So,
into from really any computer.
I mean, it's literally
because they have. And
my IT guy has like a list of like 40 things that
Yeah.
I'm like, okay, do it now. And he's like through like 30 or 40 different platforms to get people out of.
Oh,
So-
shutting off all the access.
yeah,
shutting off all the
that's the
access.
hard. And there's some. I mean, you have to do. I mean, you should be doing. Your IT department should be doing at least quarterly audits of like the systems that everyone's using and like who has
Yeah.
seats in what system. And a lot of times that's not happening, especially in smaller places that have a limited IT support.
Or
and then all of a
people-
sudden a year goes by and we have people that have been terminated for a year who still own seats in Salesforce. And
Oh,
you're like,
yeah.
what?
We just did an audit, and
Yeah.
there were people
It's
that were
bad.
before I got there. I've been there for 4 years.
yeah.
One thing I'm seeing too sometimes is if you are a company that have work phones, right? So you've got your personal phone and your work phone, but you have all of the clients are calling you on the work phone, and then you have all of that information, so you need to get all of that back too. But then when they're leaving and they're like, oh, well, I've had 6 years of family pictures on my work phone. Sorry, it's a work phone. It's not your personal phone.
Yeah, give it back.
It's really hard. And there's always been crying. I mean, there's always like, that's my baby's first birthday. I'm like,
Oh, I was happy to
use
give that work
your-
phone back. I'm like, take it.
Use your personal phone for personal. Use your work phone for work. But
Yeah. Okay. Moving off the ban, and I mean, September 4th, we'll be watching. That's the date that people need to be paying attention to, and all the things leading up. But what's kind of been the next big hot topic of the summer? I mean, we know we went through the overtime exemption and all of that, and we've been kind of helping clients through some of that, and that seems to be continuing. Obviously, it increases again. That's another
January
one that
1st.
I was in support of. I was like, I was the person that I'm like, yeah, I mean, even at 40, what is it now? 43,888. I go, you still don't really need to be working more than 40 hours a week. And if you do, I think we should pay you because it's not a huge
but the next
amount
jump
of
is
money.
going to be a bigger jump. I
The
mean,
next jump is a
gonna
bigger
be
jump. Exactly.
a
It goes
lot
to
of people,
58
especially
something,
for
right?
smaller businesses.
Yeah.
So
That's definitely been kind of the second biggest thing of the summer is dealing with these overtime changes. And even if there aren't any changes happening this year, exemptions are something employers struggle with
Yeah.
across the board, right? A lot of times I'm looking at them with people and they think, oh, they're paid a salary. Like that's it.
Right.
And we have to go deeper
There's
into
a
it. Well,
test.
we
Right.
need to go beyond that. What are they actually doing? Or they're paid a salary and they manage 2 people, so we're good, right? We need to talk about it a little bit more. I think one thing I'm seeing with a lot of folks is sort of this trepidation to reclassify people, or this fear about how it's going to be perceived by the employee, like it's a demotion or it's less prestigious to be paid that way. And so I'm having a lot of conversations with folks about, look, this is your commitment to the employee that they're being paid correctly for the time they're working. It's actually beneficial for an employee to be eligible for overtime, right? Because you're making more if you work more. But I think there's this sort of perception around it that I
There is-
wasn't expecting as
There's
much.
a
Stigma,
huge stigma. I
perhaps.
remember that from my days of like, we had some managers that were non-exempt and some were exempt. It was based on their duties, right? And we had to go through those duty surveys every single year and make sure everyone was classed. And there would be times where we had to change based on the outcome of those surveys because they were only managing like 1.9 FTEs, and really they were a salesperson at heart 50% of their time. So, but there was always that reaction was so poor. And I'm like, but you could earn more money. Like,
Yeah.
this is win-win. Like,
Well, we kind of dealt with
we
that.
have you working 55 hours a week, and now we're going to pay you overtime for it.
We
like,
had to
that's good.
reclassify a couple hundred employees when I was working in pharmaceuticals in 2016. Right, we got right to the end of and almost approached the date, and it was like, oh shit, we better do this. So we went through, and basically they were scientists that were making under like well-educated master's degrees in chemistry, making what was it, under $36,000 or something crazy, but like we're in the South. And so that's another issue too, is some of these employers in like Alabama, Mississippi, like this is going to impact them way more than some other communities that are used to paying closer to this like minimum threshold to be exempt or salaried employee.
Or they didn't meet that administrative exemption, really. I mean, there are some salaried people that are in certain fields that still don't meet those exemption requirements. And I think that's where I've seen some of our small businesses get that classification screwed up. They just think salaried, certain amount.
And the well-educated
And I'm like, well,
chemists,
not
though,
really, 'cause based on what they're doing, they don't hit any of these categories for exemption.
But hell, on the flip side, I explain this to somebody at least weekly. It's like, you can always pay everyone hourly. Like there's like that's a thing you can always do. You can't always pay people salary, but you can. There's doctors, there's lawyers, there's consultants, there's engineers that are, you know, could be making upwards of $300,000 a year. I mean, you can always do that. So that's something that people are like, oh, I can? Yeah, sure, shit, make everybody hourly.
Yeah,
like that's fine.
You can give them overtime. You just can't not give overtime to the people who just
right,
work
if they
overtime.
work over.
Right.
Well, I think a big thing too is that, you know, there's this huge kind of a obligation. Oh, the phone rings on a Saturday, I've got to pick it up. And then you're on the phone for 20 minutes. And if you've worked 40 hours and you're hourly, that is work and that is overtime. You know? And I think that's going to be the big swing. And hopefully, like you said, it might help some of these people that are making, you know, $43,888.
Yes,
you know,
I mean whatever it used to be, $35,000, and I'm like, that's not enough for us to not be paying you the minute you go over 40 hours.
Right.
You know, it's not. So that's another one that I'm in support of, because I think, you know, if you're earning $40,000 a year, that's probably not a role that we should be asking you to work much over a regular work week.
What are the complaints you're hearing from employers, like people that are, see, in the community where we are, which is in Southeast North Carolina, we've got listeners from all over the place, but in the community where we are, there used to be a beach tax. So we live in this like coastal community, and so everybody made 20 or 25% less than 2 hours down the road in Raleigh, because you're lucky enough to live at the beach. But over the last 7 to 10 years, this community has made extreme strides, as evidenced by some graphs that our regional economists recently published, which our community is now making a greater average wage than the North Carolina average wage, which never happened. We were severely depressed compared to even the average North Carolina wage. So I feel like we've done a lot better, but there are communities and even employers in our community that still think the beach tax is a thing. Oh, they're lucky to live here. But they're not. They're trying to pay their bills, and inflation is real. And so, like, what are employers still being stubborn about this, or are people saying this is the right thing to do? I need to get prepared. Help me get prepared.
I think a lot of it is educating. You know, like I said, you know, when we talk to people about it, there's just a lot of misunderstanding about what the exemptions mean in the first place, right? And maybe some opportunities to correct how it was set up to begin with, even before we get to the rates changing this year and in January, right? And then also sort of breaking down the consequences, right? You know, what does this mean? Am I on the hook for all this? Well, how much do they actually work is always my first question, right? If they're not working over 40 hours a week, you're paying them the same, right?
You should be good.
It should be okay. Now, of course, we need to make sure your policies address if you have unauthorized overtime, that, you know, you can be disciplined for that. We've got to pay them if they work it, of course. But really sort of walking through what it means. And then there is some adjustment to the idea of, I have to ask these people to track their time, right? Because that's a conversation too, is what are we doing with these folks? Are you tracking time? Because if we have a complaint, if we have an issue, I always talk to people about, well, what's the discovery process going to look like, right? If you have time records, we know what they worked, we know they didn't work overtime, but now we're in the day and age of, you might answer your phone on Saturday, or you might open your email and scroll through it and respond to a few at night while you're watching TV, that's compensable time, right? And because Microsoft or whatever platform you use has those records, we can get to that, but it's an expensive process. Wage and hour is one of those things that's usually, depending on your policy, may not be covered by your EPLI, right? Like that's a hot exclusion in a lot of policies. So I
Those
think
are time intensive to do the research on wage and hour.
Yeah, I think the adjustment to the change of asking people to track time is one of the biggest things I'm having conversations about.
I would agree with that. So it was pretty easy. I had one particular client that it was an easy change. It affected a handful of folks. I communicated it so that the message did come across like really positive. Like, listen, if you work overtime, we want to make sure you get paid for it. And every employee was like, awesome, great, no issue. But it was already an organization because of what they do, and they do construction and they have project-based stuff where they charge their hours. They already all report time. Everyone down to the CEO reports time. So it was no change there. The ones that it's harder with and where we actually just said, this affects one or two people, you could just increase their compensation a few $1,000s. You know, we kind of said, what's the right move, right? Do we classify it a non-exempt, or do we increase their compensation and keep them in an exempt classification, right? So, and that was easier because we didn't have a good system for keeping time, nor did we really want one or two people in the company out of the 20 having to report time. And like, who was going to keep track of it? I'm there 4 hours a week. So we kind of had to look at all, but I would agree, if you don't have a good system for timekeeping, that's probably a bigger hurdle, because the majority of those folks aren't really working overtime anyway. So the comp the actual OT dollars was not a concern for at least any of my current clients.
The nice part is, even if you don't have time tracking options, there's always add-on applications. So like QuickBooks has T-Sheets, Gusto's got easy time tracking. If you work in hospitality and you're using Toast or Clover, they all have time tracking and payroll options. So like, if you don't think you have it, you probably could get it really easily.
You can upgrade. It's a minimal amount.
Right.
It's an add-on on most of those systems, but it's worth it for $500 a year.
Yeah, so
I had somebody say, and I won't say who, but somebody said, well, just do your time cards, but just put 40 in everything and then you'll be fine. I was like, what? No, that's not what we're going to do. Like that's exactly the opposite of what we need to be doing.
Right.
It starts to look a little suspicious when it's
Yeah,
like
it's like-
when you get just like
every
8 to
week.
5 with a noon break every day, you're like,
And you're like,
okay,
really? It's 40?
I meant accurate timekeeping, not just timekeeping. Yeah.
So I've really recommended that everyone just buy those add-ons on their payroll system. It's not that expensive.
And
then they get to have an accurate time.
The biggest, I will say, the category I'm having the most conversations about is salespeople.
Yeah.
Because outside sales is really narrow and arguably doesn't have a lot of relevance in 2024, right? Like, how many truly door-to-door or visiting salesmen do you really have? And so we have a lot of people trying to squish them in that, or squish them in the administrative exemption. And we have to have that conversation. You know, these salespeople are working in your office all the time, or they work remotely. Like, that's considered an office, right? They're not visiting their customers at their locations. We're not hitting any exemption.
Right.
You know?
So tell for our audience that might not know, the problem with that for sales is because usually they earn a large majority of their compensation comes from bonuses and commissions, and you can only count a certain percentage of that towards that compensation, correct?
Right. So you have to have the minimum threshold of compensation. You can take, I think
it's 10%.
10% of that can be made up through commissions. But, you know, if you have someone who's really, really commission driven,
Yeah, a lot of those
probably not
salesmen, they
gonna-
make like a base of like 30 grand and then they probably make 100 for the year, but 70% of that comes from commission.
I know people still in this community that are $0 base salary,
gosh.
100% commissions. It's terrifying.
That's so stressful.
Yeah.
Yeah.
so
So,
those
yeah,
are just, those are
those
complex
are tricky,
and they need
yeah.
some attention. But
They can
don't
call
just
Katie Green.
don't just assume that everyone does it this way, or we've been doing it this way, that you'll continue to skate through. We're also seeing a lot of enforcement. Even, you know, North Carolina is a pretty considered a pretty employer-friendly state, right? We don't have super active enforcement generally, historically, but we are seeing upticks in audits. And it's coming from different sources, right? There's been a big push, and we've seen announcements from different agencies that they're sharing information. They intend to share information, make referrals to each other. So don't assume that it's just going to come from an employee complaint. But employee complaints are also on the rise, right? Because all these things are in the news. You're having employees come with questions. Well, should I be getting overtime now? Or is my non-compete still good? So enforcement's on the rise, and employee awareness of these issues is on the rise, which are places that can trigger scrutiny.
So what's the hot date we're looking for with this ruling?
For the overtime salary threshold change, July 1st was the first change. We'll have another big jump, a more significant jump to just under 59,000 January 1st. There are some lawsuits that are challenging this as well. Also one in Texas. There was an injunction that went into place, but it's only for Texas state employees. So if you work for the state of Texas, living remotely in North Carolina, the overtime change did not apply to you. But that's the only litigation that's issued a decision I'm aware of right now.
Roger. All right, we've got 3 minutes left. Do you want to hit her with a question from the audience, or?
Sure.
All right.
Okay, these are just some good like our advice questions. Let me see which one. I wrote down a few. Okay, this is a good one. We'll get some feedback from you on how can I regain my confidence after being fired. I'm actively looking for a new job, but whenever I find a posting that interests me, I'm reluctant to apply because I'm afraid that my mistakes in my previous job will come back to haunt me. In addition, I'm not good at interviewing due to nerves and being able to effectively show my strengths. I'm far better through writing, and I'm kind of just in a mental health slump at the moment, and it's completely erased any confidence I once had. Any advice?
Oh gosh.
That's a tough one. I mean, first, I think it's hard to be in that position, right? Because you get confidence from the position you're in, and feeling like you're at a disadvantage or you're working an uphill battle is hard. I would say, remember you're a person. All the people who are interviewing you, screening you, hopefully AI aside, are people, right? They've all had all types of experiences in the workplace. There are things about you that will make you shine. Focus on those. I've seen some really interesting commentary from kind of executive coaching or career coaching sites about using ChatGPT to help interview prep, right? Like telling them the position you're interviewing for and having it spit out interview questions and suggested answers. Practice. Gain some confidence through going through things you think you'll have to answer, and especially talking about your departure from your last company, right? If you know that's an emotional or difficult thing to talk about, get a narrative that you feel comfortable and confident delivering.
I love that.
Yeah, I think that that's probably the best place to start is like, I think what's making you probably nervous is like, how do I talk about that when it's brought up? So being able to create something that feels honest and not that you're telling a story about it, but also isn't oversharing the information and is keeping it kind of like generalized and positive. But I think you're right. It's about kind of practicing. And I think I would say go get some support, and that may be hard if you're not in a job right now and working. It may be financially straining or tight, but there's a lot of free resources out there that you can go and give yourself some space and time.
Call me. I'll take your call.
Beth will give you some free advice.
Oh, it just tickles me.
Call someone with mom qualities.
Yeah.
I think that nothing builds confidence like getting back in there and just trying it and practicing it. And I think that you gotta just hit go and kind of force yourself sometimes to jump back in and start. And those first couple interviews might be rough, but the more you do it, the better you're going to get at it too.
Go back to season 3, episode 2 with Jarvis Harris when he said, get in there and just be yourself. Remember, that's when he landed his big deal that he always wanted. He was like, I just started loosening up and talking to them like a real human being and being himself. And look where he is now. So it's great. Go watch that episode. All right, guys, we're going to wrap up. I want to thank Katie Greene. Thank you so much for being here.
You.
Katie Greene from Michael Best. Why don't you tell everybody where they could get in touch with you?
Yeah, the best place is our website, michaelbest.com. We have an office here in Wilmington. We have offices across North Carolina, and we are a nationwide firm. We're headquartered in Milwaukee, and as of earlier this month, we're in California, which has
Ooh,
been
that's
exciting. Yeah.
California law is
I was
different.
like, exciting. Is that the word for California
labor law?
employment law?
We have so many client
You'll
needs
get a
for
lot
it,
of business.
Absolutely.
Thank you all so much.
All right, guys.
Yeah, thanks for being here.
That's a wrap. And if you like what you heard, make sure you hit subscribe on YouTube or wherever you are listening to us on the podcast platform. So thank you so much. See you next time.